What should I do if I want to serve a statutory demand? A creditor who serves a statutory demand for a disputed debt takes a big risk on costs if they do not withdraw it when the debtor has raised a dispute. Don't consider using a statutory demand instead of a county court claim unless the debt really is undisputed. Statutory demands are not supposed to be used as a debt collection tool. In reality, many creditors use them exactly in this way. Do remember that if a creditor persists with a statutory demand and the debtor gets the demand set aside or an injunction against the presentation of a winding-up petition, then the court is likely to hammer the creditor in costs even if the creditor subsequently wins the dispute, in normal proceedings. Do, above all, take some free advice from a solicitor at Helix Law before serving a demand. What happens after statutory demand? When the statutory demand has been served, the creditor will be entitled to petition for a bankruptcy order against an individual, or for a winding-up petition against a company after 18 days. Therefore, anyone who receives a statutory demand must take steps to address that demand within 18 days or risk a petition being issued. For an individual where the debt is disputed, it is usually appropriate to request that the creditor agrees to withdraw or discontinue the statutory demand. Otherwise, if there is no agreement, the individual debtor should apply to the court for an order, and their costs, seeking the set-aside of the statutory demand. In the case of a company, initially the company should request undertakings that the creditor will not issue a petition, failing which the company will need to obtain an injunction order from the court preventing the creditor from issuing a petition.